Hello everyone, welcome to Stenographers. This is legal dictation number 9 of a pre-decided case at 100 words per minute. Ready please? The built-up areas were not to be disturbed even if such areas were not in conformity with the master plan and the zonal development plan. Dealing with the submission pertaining to Section 14 of the Act, it was observed that the main part of the section prohibits the user of a land or building in a zone otherwise than in conformity with either the master plan or the zonal development plan for the zone. But the proviso lays down an exception to the main provision and states that the previous user to which the land or the building was being put on the date on which such plan came into force can be lawfully continued upon such terms and conditions as may be prescribed by regulations made in that behalf. It was observed that it is true that the proviso states that the continuation of the user has to be upon such terms and conditions as may be prescribed by regulations made in that behalf, but that does not mean that the exception recognized under the proviso does not operate so long as no regulations are made. The words upon such terms and conditions as may be prescribed by regulations made in that behalf in the proviso only enable the authority concerned to make regulations prescribing terms and conditions for the continuation of the previous user. If regulations are not prescribing such terms and conditions, it only means that the continuation of the user permitted by the proviso would be subject to no terms and conditions. In other words, it was held a person does not lose the benefit of the proviso if he is otherwise entitled to it merely because the authority concerned has not chosen to make regulation prescribing terms and conditions for the continuation of the previous user. The concerned authority, by closing not to avail of the enabling provision in the proviso, cannot circumvent the rest of the provision in the proviso and deprive the petitioners of the benefit conferred thereunder. The learned counsel for the appellant, however, contended that where, as in the present case, the language of the main enactment is clear and unambiguous, a proviso can have no repercussion on the interpretation of the main enactment so as to exclude from it by implication what clearly falls within its express terms. There can be no dispute to the proposition sought to be urged, but the proviso to Section 14, as already noted above, carves out an exception to the main rule embodied in Section 14. The principle sought to be urged is accordingly of no consequence in the instant case. The submission that where the language of a statutory provision is susceptible of two interpretations, the one which promotes the object of the provision, comports best with its purpose, and preserves its smooth working, should be chosen in preference to the other which introduces inconvenience and uncertainty in the working of the statute, should be preferred, is equally of no avail.